Session of the Utah Board of Oil, Gas, and Mining for June 27, 2018. We'll turn the time over to you, Director Baza. Welcome. And for those of you that aren't aware, and those of you that are watching from YouTube, Mr. Baza has been appointed to a very critical and important federal council. John, will you want to introduce that to the board a little bit and tell them what you're already involved in a council, in a trade association council. Will you link the two of those together?
Sure. The Division of Oil, Gas, and Mining is part of several national organizations, IOGCC for oil and gas, IMCC for mining, and then a third one called Groundwater Protection Council. As part of that, and they all represent state governments throughout the United States, focusing on those issues. And Groundwater Protection Council is specifically aligned to look at issues that cross over between groundwater protection and oil and gas development in the United States. For example, underground injection control is a big matter that GWPC handles. Well, through that and being on the board of Groundwater Protection Council, unbeknownst to me, they were looking for people to represent states on the National Petroleum Council, which is it's a fairly prestigious group. It includes many representatives of the oil and gas industry at the corporate executive level. And as far as I know, there were only 2 states asked to participate on the National Petroleum Council. Utah was one, and then the second state was Alabama. And both of those came through recommendations from the GWPC. So I feel very honored. I think it certainly is a big deal for the state, but I want to assure you that I'm not the big deal. So we'll be working very hard to study critical issues. It's an advisory council to the Department of Energy. My appointment letter came from the Secretary of Energy, Rick Perry. So we're just going to push ahead, and I think they have a couple of meetings a year in Washington, D.C., as well as all of the subcommittee work that happens mainly by email and conference call. So I'm looking forward to that.
On behalf of the board, we want to congratulate you and do whatever we can do to help you be successful in that job. One of the things that Director Baza will be looking at on this is the produced water. Is there some way to take produced water, and do you want to mention that, just kind of where that's headed right now and what's...
Sure. We have been working on that for just about a year. The board of Groundwater Protection Council passed a resolution in April of 17 saying we need to be at the forefront of studying produced water and beneficial use and reuse of that water in the United States. Just in perspective, we have more water produced in oil and gas wells in the United States each year than goes over Niagara Falls in a single day. So that's a lot of water. And if it could be put to good use, even just to displace current uses of fresh water, it would prove to be of some value. Right now, 90% of the produced water in the U.S. is just being re-injected back into the ground, either for enhanced recovery or for deep well disposal.
And for arid states like Utah, being able to use produced water for agriculture, grazing, wildlife would be spectacular.
Absolutely.
Okay, with that, will you move? Thank you for doing that.
Thank you. And for those out watching this on YouTube, I'm John Baza. I'm the director of the Division of Oil, Gas, and Mining. I want to welcome the board to your field hearing in Delta, Utah. And I first of all want to thank everyone, and I mean everyone, who was involved in this field tour we had yesterday, where we visited the Magnum project outside of Delta and also the Materion beryllium mine. I especially thank those 2 companies for allowing us the time to be able to view their operations and have an explanation of those things. But I also want to thank all who made this possible. There's a lot of moving parts to both having a board meeting and then having it out of town. As I was here last night helping Tom Thompson and Paul Gedge set up the room, it's like watching some concert band roadies put this thing together, and then obviously at the end of it they'll tear it down. But it was fascinating to watch and help with that. I want to thank them, and I also want to thank all of the members of the division who have participated as drivers, as people explaining the processes in the individual vehicles. And I especially want to thank the board, because even though we all get paid to do this, you guys aren't. So thank you for your commitment and your efforts to volunteer on this board and provide the critical thinking needed to create policy in these matters. The first thing that we have on our briefing agenda, in fact, the only thing we have, is to discuss drilling and spacing unit surface location discussions. And this primarily came about because we had asked our AG's office to provide us with some guidance where we had off drilling unit surface locations for drilling wells. And I won't steal anything from Mr. Doucette. Dane Doucette is our permit manager. He's also a petroleum engineer. He was hired for that within the division. He is going to explain where we're at with this and provide you with some information. We aren't asking the board for any decision-making or commitment at this point. Just want to make you aware of this issue and how it may come up in future matters to be decided by the board. So with that, I'll introduce Dane and go ahead and take it away.
Okay, thank you, Mr. Bozza. Chairman Gill, members of the board. Just to start off, I've been maybe made fun of a little bit that I only have 3 slides and one of them's an introductory slide, but this is a briefing session, so I'm going to attempt to be brief. Like Mr. Bozza said, I'm just going to give a kind of a background of what the division has seen as far as issues and how they came about with surface locations that are not located on the drilling unit. So as you are aware, these have been addressed. The situation has been addressed in various board orders. For example, 139-151 states that the operator must have that they're allowed as long as they have acquisition of proper surface and subsurface estate authorizations. 139-149 states that provided proper surface and subsurface authorization for such a location has been obtained as required by law. So the wording such as this has been in the board orders. I guess what brought this up is we had a company ask us not to approve an APD for a well that had a surface location off the drilling unit. And we're looking into, okay, well, why can we not approve it? And part of the problem is some companies tell us that they actually get authorization from the mineral owner and the surface owner when they're off location. I had one company tell me that we don't believe there's any authorization required by law, so therefore we feel comfortable making the statement that we have all authorizations required by law because we don't believe there are any. So in the situation where we were asked to deny the APD, the companies whose APD we were asked to deny had made the certification we have all surface and subsurface authorizations required by law. And the counsel, or the advice from our attorneys was you should deny this. And I asked, well, I need a basis for denying it. I don't feel comfortable denying it. And that's when Mr. Alder crafted this memo outlining his position in legal interpretation. I won't reread the memo or go into detail what it says. You have a copy of it. You can do that yourself. But I do have this one slide which isn't labeled really great, but it's going to force me to explain it. But this is a laydown 1280. So the big black lines are sections, and then the smaller red ones are quarter sections. I did a laydown 1280 because it fit the the screen layout better, so it could be either. So if, you know, a lot of the wells are drilled with a surface location that's on the drilling unit, not a problem. Several others, I'm trying to highlight it with the mouse, but this yellow square up in the northeast corner here would be a surface location that's off the drilling unit. They have a surface use agreement for that, so that would not be an issue. But the one where we had it was a similar situation to this one down in the southeast quarter, is the company had the yellow surface location, but they did not have the surface or minerals in this blue rectangle. So our question is, you know, should they certified they had all proper authorizations? Do we debate that? Do we just take their word for it? What's, you know, what should our position be? And Mr. Alder's interpretation through his memo was that companies that, if in this situation, the company drilling this well would need surface authorization from the surface owner in the blue rectangle to cross their lands. And basically, that's the gist of it. We at the division have not enforced that as of yet. We have not done anything with that. So we're still under our old practice of, if they have the certification that they have proper authorizations, we're still approving the APDs. But we do have new guidance from our Attorney General's office stating that there could be an issue, that his interpretation is that we should be verifying that they have this surface authorization of this surface owner that's between their drilling pad and the drilling and spacing unit boundary. I think that outlines basically everything. So if there's any questions, I'd be happy to answer them. If you have any questions about the memo, and specifically, you probably should ask Mr. Alder. I guess that's it. Is there any questions from the board?
Board members, I'm going to turn to you first. Gordon.
So if I was that surface owner in the blue, I would be a little confused if the company came to me and said, we need a surface, or I don't even know what you call that. We need to get your authorization to cross your land. I would just be a little confused, you know, because you're going to be down 3, 4, 5, 6,000 feet there.
Right.
I would be wondering what's my damage? Why are you asking me? But I do understand that, you know, I do have a legal ownership of all that. What do I own down there? Don't own the mineral if I'm the surface owner, but I own everything down there.
The ground to the center of the earth, right?
But yeah, I would just wonder what's my damage, what's my impact, you know, should I be paid for that? I don't know how I'm being hurt by that. That would be the questions I would have as a surface owner.
And we have those same questions as a division. Seriously, is, you know, one concern is, do you want that landowner to be able to hold the operator hostage from drilling the well when you're really not doing any damage to them?
Some surface owners, you know, would be, well, yeah, $20,000 you can go through, you know, and that could create a problem for an operator. So, but yeah, whether that should be brought to their attention, that's a good question. But I wonder what the damage or the impact is to the surface owner.
Right.
Do we have any other questions from board owner or board members? We have, Steve, do you want to come forward? And then we have one of the top title lawyers in the state here in the audience. It's an invitation. It would seem like to me, go ahead.
We have probably a couple of attorneys who are very good at title. And this memo was not distributed earlier except to the division. And so Mr. McDonald, Fred McDonald, was given a copy of it earlier. He may have a few comments as about how the board may want, if the board wants to proceed. As was stated, I don't think the idea was that the board needed to take any action, just wanted to advise you of the memo and the advice that had been given since. This has been raised before the board in at least 5 or 6 hearings where this is part of the order, and we've suggested that the order be more specific, and in the past the board has deferred and not added more specific language to their orders. So the language that's been used, it continues to be as authorized by law. That is troublesome. I think at the hearing that I was not at in April or March, maybe it was March, the board suggested they might want to do rulemaking. I'm not sure rulemaking is appropriate to address this problem, but it's a rare problem. Most of the time, you're not going to have this gap, but nevertheless, it's something, it's a legal issue as to who is the owner and who has the right to consent and what are the damages if you trespass. The interests that are protected are the interests of the mineral owner as well as the interests of the surface owner. And my review of the law was that if the purpose of drilling that well bore is not to develop the mineral beneath that land, then the trespasses against the surface owner. That's essentially what the memo says. But certainly I know Mr. Chicken addressed the board on this issue a couple of months ago at the board's sort of spontaneous request. Mr. McDonald has only had a few minutes to read the memo this morning. He may want to address the board.
Mr. McDonald.
Commissioner, while they're coming up, can I make one further comment? There is another issue that I didn't mention that I don't know that we want to solve, but a company may make the argument that the well off lease or off drilling unit well could be interfering with their ability to put their well bores in to handle their minerals, and I think the division's preference was they work that out amongst themselves. If they can't, that would be something that would come before the board, and they would have to convince the board why that was the case. I don't think the division wants to make that decision on a case-by-case basis.
Let me comment on that. The last hearing, question was asked, what level of knowledge do you have of the well bore location at 2 miles, the end of the 2 mile line? And they said plus or minus 5 feet. So I can just, speaking for myself, it seems like that with that level of accuracy, you'll have to have a higher level of evidence to convince the board that is an issue. It's solvable, but if you were blind drilling like we used to before directional drilling was available, yeah, I'd agree with that 100%. We didn't even know where our wells were when we really tried to know where they were. So with that, Mr. McDonald.
Yes, Mr. Chairman, Fred McDonald. I'm a practicing oil and gas lawyer. You've been in front of the board many times. I also do title work as well. I think to frame this, and again, as Mr. Alder said, I've had about 5 minutes to review the memo that he provided. I think the important thing for the board to understand is the jurisprudence is all over the board right now.
Yeah.
As to what rights are involved and whose authority you have to have. Utah, in typical case, has just very little law on anything on oil and gas. And the courts that have decided this have kind of come both ways. You have Texas jurisprudence that says you can drill and it's not a trespass at all. And then you've got the situation we've talked here is a surface owner would normally own from the heavens to the middle of the earth of his land. So the question is, who owns those rights to drill? Do you have to get an easement, just like you would on the surface, for any subsurface use, since the surface owner would own that? The complication here would be also is if you look at that blue rectangle, if you had a third-party lessee that owned the minerals and that lease provides for exclusive rights to drill, there's a question there as well as do you have to get that lessee's rights because of the grant of exclusive rights to drill. Now, you know, the question there is damages. I mean, if you're just passing through and you're not extracting any minerals, then what are the damages? And you know, are they entitled to core data of all the soil that you take? Or, you know, there's all kinds of unresolved issues. I was involved with that first Newfield order that incorporated this. It was incorporated at the suggestion of the division at the time. And the way we looked at it was, well, if a company's going to self-certify, they're also making the business decision that they feel in a good legal position that they're not committing trespass, because their damages to the surface owner or a third-party lessee or a mineral owner, if it's unleased at that time, are going to be much greater than the, you know, the regulatory violation perhaps, or something of that nature here. I think the idea that a self-certification is sufficient for the division's purposes, because that alone would get the division there. For example, when you drill a vertical well, they don't do a title opinion on who owns the surface, or if the permittee has the operating rights to be able to drill it right now. It's self-certified, again, on that same basis that a company probably would not come in front of the division if they didn't think they had the legal right to do it. I think the circumstance that Mr. Doucette has explained to you is a perfect example of how the system works. It's out there. If a company feels that it has the rights, and it would be trespass and asking for an APD situation, if the board denies it, it can be in front of the board, and you know, you can deal with the issues, or if the legal issues aren't there, that they can take legal action as necessary to protect their rights. So, you know, my suggestion would be is I think the language of the orders needs to be consistent. There shouldn't be any differences between the orders that the board's doing on that certification. But the concept that a self-certification should be sufficient for the division should be sufficient, and then if somebody objects, then the matter goes forward with that. But otherwise, it would go forward, and then the company is taking the risk on its own that it would have liability to parties outside of that. That's just my take in the first 5 minutes of reading that memo. But you know, I don't think the board wants to get into rulemaking, because until there's more clarification judicially, you'd be putting yourself in a tough position other than going forward the way that the orders have been.
I have a couple of comments, board members, if that's okay. Back to you, Gordon.
Oh, just a quick question. When Newfield was the blue owner there, was it their mineral or their surface rights that they were concerned about?
It was their mineral.
Their mineral, okay.
So I think there's 2 or 3 components of this from my early thought process about it. The first is we ought to have a standard clause that either by board order, we got Mr. Chicken out here. We'd like to maybe give him an opportunity to comment if he has some thoughts on this, but he may be completely unprepared and surprised and all the things that lawyers hate. But there's kind of a go, no-go decision here. The first one is, should we have self-certifications? Do we want to have, you know, it works until it doesn't? And then if it doesn't work, then the board has the option of saying self-certifications are no longer available, and we need to have a demonstration of some sort of right to do that. The second one is in the bottom situation where you have the blue rectangle. Is there a trespass there? It appears to me that from my little knowledge that that would be clearly a trespass of the surface owners. And then you have the third issue is, are there mineral rights by law? We don't know the answer to that. Or a mineral right by contract, which is what Mr. McDonald mentioned, that would have rights involved. And then, you know, if a company came to, let's say, Mr. McDonald or Mr. Chicken and said, we want to have a legal, you know, we want to be legally compliant, and you need to tell us that we are. And in an area where the law is so gray or incomplete, would you have malpractice insurance somehow triggered in all of that? And so the idea is that from my thinking would be, as long as it's working and it's administratively efficient, it's something that we should pursue until we're told otherwise. To the extent that you have the blue box needs to have some sort of legal right to get across it. To the extent as a courtesy or something where there's a mineral right that it has, by contract, some sort of a power or right, lawyers call it an executory right. That's the right to sign on behalf of someone else. And if you want to take it to its ultimate, that's called a usufruct. And that's the right to get money from from land you don't even own. And I mean, there's all the ways in the world to give people rights to property and to sign on behalf of, sign and bind someone else. It's like a power of attorney. You can sign and do things like that. So it's not an easy issue, but I think from my perspective, and again, I'm speaking just for myself, I think the idea of company certifications makes sense and it's administratively efficient. To the extent we start hearing that there's problems, then we have to visit whether that self-certification is a process or program that will work. I'm taking that out to give you, Mr. Chicken, time to come up to speed. But we're talking about off-site, off-location, off the spacing unit, drilling locations in a atmosphere where the legal rights of the mineral owner is either unspoken or unknown. And it's probably something that you've dealt with before. To that extent, could we surprise you? And whatever you say is non-binding?
It's fine, Mr. Chairman. I'm actually I'm okay to just go with this. I'm very familiar with this in the 5 states I practice in. I'm actually presenting to the North American Land Title Analysts annual meeting in September on the issue, or on the issue of subsurface trespass. I can tell you that what I advise my clients when they come to me and say, and it's more and more common because you can do your kick outside before you go into, so when you hit your setback, you're already in the formation at depth and ready to perf, so you get more perforated lateral. When they come to me and ask that, there's a couple of different situations. The first is, you need to have, in all 5 states in the Rockies, Utah, Colorado, Wyoming, Montana, North Dakota, trespass is defined as the physical touching of another's land with your body or an instrumentality with the intent to do so and some form of damage caused. Therefore, a wellbore can trespass, and there are cases in Colorado and cases in Wyoming. I don't believe there's one in Utah yet that specifically addresses wellbore trespass, wells going into land that isn't owned. And because of that, and because of, I mean, Colorado's actually got cases that even go so far as to talk about seismic trespass and how you can trespass by just learning mineral information from the land next to you. Because of all those cases, I advise my clients that you need, if you are outside of your drilling unit, you need to either have a lease that is covering both inside and outside. So it's not enough to be able to say that you've got this So for example, and I'll use Mr. Moon as an example, you have 2 tracts. A lot of landowners will lease separately in each tract, right? They won't give you one lease that covers 10,000 acres. They'll give you 10 leases that cover 1,000 acres each. You can only use the right to surface development to develop the minerals covered by that lease. So in the example that you have up there, if the top one, the yellow one, if that was your only lease, you couldn't use that surface to develop the minerals to the west of there, right? Then you have to get surface permission, in that case, from the surface owner. But you're also drilling through minerals underneath. The surface owner owns surface to the center of the earth, right, and everything around it except for the actual resource that's there. But if your wellbore touches that resource as it's on its way, even if you don't perforate, as it's on its way into where you're gonna perforate, you have technically trespassed. Now, again, you got to have damage, and so sometimes it's very difficult to articulate that damage. You know, one way that you can do that is wellbore setbacks. Let's say you have 2 operators, and this actually just happened in a case in Texas the Supreme Court heard, but you had 2 operators, and one of them wants to develop on the 640 that they're in, and the other one wants to drill through that 640. Well, if they're drilling at about the same depth, it costs a lot more money to like go underneath somebody than it does to go at the same depth. And now you could actually have non-perforated wellbores in the same formation as perforated wellbores, and they have to have then setbacks between them. And so the damage in those cases is very often that the person that's drilling through is taking up my wellbore spaces. So that can happen as well. So, you know, my advice to my clients is always, unless you have that situation where your lease is overlapping into the spacing unit and you can develop all of that as kind of one lease, that you get permission from the surface owner and you get permission from the mineral owner. And there's a subset of that even, which is, what if the mineral owner right next to you is not leased by, you know, an EP or a Bill Barrett or a Crescent Point or a Newfield or somebody, you know, an Axia, that we're fairly certain they're going to start development? It's just owned by a broker. And the broker just lets that, you know, you go to the broker and you get your subsurface easement from the broker, and the broker lets that lease die after the 5th year. Nobody wanted to pick it up, couldn't sell it to anybody, the lease dies. Guess what else just died? Your subsurface easement. You're now trespassing on that mineral owner's unleased minerals. So it's another subset of that where I really say, look, you know, if right next door you have, you know, a bunch of vertical wells and they're producing and they're probably going to produce for another 30 years, you're probably fine just getting subsurface permission from the lessee. But if it's a broker or something like that, you probably want to go to the mineral owner. Otherwise, you might find that you put all of your wells in thinking you've got this easement, then their lease expires in 5 years, and all of a sudden all you really have is, you know, 10 horizontal wellbores trespassing on somebody's lands. Now again, the damage in these cases is difficult to articulate, it's difficult to prove. A lot of these cases, that's why we don't see these cases very often, is because it's hard to make that happen. The case I referred in Texas, Lightning v. Anadarko, was a very different outcome. In that case, the permission was only acquired from the surface owner. They did not get mineral owner permission, and they talked about specifically, well, you're entitled to your reasonable share, not every drop, the fact that their wellbores are going to pass through your minerals and not be perforated and producing. You know, the amount of loss is negligible. You don't need it. And so the law in Texas has departed significantly from what we see in the Rockies, where as long as you get the surface owner's permission and as long as you don't perforate in that other mineral owner or lessee's minerals, you can pretty much drill wherever you want. But in that case, for example, I personally believe that Lightning did a very poor job of proving their case and proving their damages. And it allowed the court to basically do something they've been trying to do in Texas forever, which is starting to build back up the dominance of the mineral estate and get back to where that was. I mean, a lot of the Rockies, for example, the pore space that's under the ground, the void that is left, that void is owned by the surface owner, and all of the Rocky states. Well, although it's been eroded, in Texas, it started out as that's owned by the mineral owner. So that, I think that's where they're kind of going there. But to me, and that's what my presentation in September is on, is to compare and contrast the effects of lightning with what the law is in the 5 producing Rocky Mountain states.
So you've got a Pew clause that says that you can only go, you know, that you own the rights to the 50 feet below the bottom of your drilled hole, the hole depth. And there's a whole different ownership. So you drill through one guy's lease.
Right, and you're in another guy's lease.
And then you're in another guy's
lease.
lease.
This gets much more complicated if you start bringing in concepts like state and federal and tribal minerals.
Yeah.
Plus you could have, you know, 30 mineral owners in that blue.
That's absolutely right, and you may have to go and get permission from all 30 of those. Now, that one I have to look at a little bit. Usually when you have 2 tenants in common, which is what a lot of those people would be if they're undivided owners, right? Let's say they all own all of that, you know, that west half there, that 320 acres as undivided owners, not in tracts. If you had it by tract, then you only have to go to the people that your wellbore is actually going to go through. If they're all undivided, then the question is, do I need all of them or none of, or just one of them? I think the answer would be, just like it is with spacing and other oil and gas concepts, you could have one person where you lease them, they own 40 acres in a 640, and you can go develop that 640. I mean, there's legal mechanisms in place to do that. Most people wouldn't, because financially it doesn't make sense. But you could technically do that under law. And so I think the answer there is, unlike most co-tenant situations where if you and I, Mr. Moon, were roommates in a house, we owned it 50-50, you have the right to exclude people from that house, and I can't, you know, and I can't tell you, no, they get to stay, and vice versa. It's different with minerals. It's different with mines. And so in those cases, yes, if you get the permission from one person, it's good enough to cover all. I haven't looked at that specifically here in Utah under current law, so I don't know, but I'm guessing that would probably be what you'd be able to do, is even if there were 30 mineral owners, I think you could get away with getting something less than all of them, right? I don't know if, I think 1 of 30 is probably dubious a little bit, and all of them is probably impossible. It is probably something along the lines of like when you unitize, right? Yeah. You're not going to get everybody to sign the unit agreement, but if you get X% of royalty owners and X% of working interest owners, then the law says you've met the burden you need to meet here. You've got as much as you need.
Thank you very much. That was really helpful to me. I appreciate it. I think the board has absolute confidence that Mr. Doucette can navigate himself through all of those nuances and suggestions as he goes ahead and approves permits. I think I'm being facetious on that. But what we can do is this. I think by saying that all applicable approvals as needed by law, when the law is gray or absent, it doesn't make sense to me. So we need to have a massive improvement of the language that we use in that, and I don't know the solution right now. But it would seem to me that is there a safe haven with what we know today, where you have to have a surface, self-certify that you have the right from the surface owner and permission, well, at least notice to a mineral owner so that they have the right to at least complain.
And I think it's consistent, Mr. Chairman.
Would certainly be it may not be completely the way to go. And Mr. McDonald, are you listening to this? That we recognize that the surface estate in the Rockies is where we need to go, and notice to one, the mineral owner, to a mineral owner, and give them the right to might be a way to go, but...
And Mr. Chairman, keep in mind, too, that what we're talking about here is APDs, correct? And what needs to be certified for an APD.
Correct.
Most of the other states that I practice in have something very similar to this and very pedestrian. It's like a box you check that says, I own the surface estate, or I have an agreement with the surface owner for the surface estate and all necessary subsurface easements. If that were to be approved, and it turns out that that wasn't the case, the matter would be in front of this board first and foremost, because it would be a challenge to the approval of the APD, which would get kicked out of court for exhaustion of administrative remedies. I believe that's what would probably happen. So they would have to come to you anyway, and so it wouldn't, I don't think it would ever be a situation where the mineral owner would be saying to the board, you know, how dare you have approved this kind of thing. I think it would be the opposite. The board would be basically saying to the operator, how dare you lie about having the certifications you need to be able to do this. And the reason I know you lied is because this guy's here telling me you didn't talk to him. He's the only surface owner, you know, or something along those lines. So I think that the point I'm trying to make is that that the first and foremost place where that issue would be hashed out is in front of this board.
Okay. Mr. Bozza, can we ask you to, and your counsel to pursue with the private attorneys and with the board counsel some suggested language that could go into an order that would give, as best we know today, some safe haven that we can then rely on of what it means, that it's a knowledgeable, you know, we don't know the basis of the law, but to put in an order that according to law doesn't make a lot of sense to me right now.
Certainly, we can do that.
If we'd look at that, and then board members and Gordon.
So my only concern would be how often does that happen?
That being the blue?
Yes. How often does that happen where we have this potential concern? Or are we taking one instance where that's how often is this going to happen? And does it warrant, how much effort does it warrant?
I would say it's definitely not a majority of the time, but it happens more than once. It's not a one-off.
So you feel like that some good effort to come up with some parameters is
Yeah, and there's two components of this. We have already plowed one of the, you know, we've got orders out there. They are all under the pilot project scenario. Can we, one of the things to look at, and I don't know the answer to this, and I'm not recommending an answer, but would it be a generic board order that says, and lists all of the previous orders and says something to the effect, to the extent off-site locations have been, this is the intent or language of the board in terms of what that sort of self-certification. I mean, the reason we have pilot projects is lessons learned. What is it that we need to know as a board? And so we're encouraging the feedback. We recognize we're going to have just exactly these kind of issues. As they come up, how do we solve them? Can we do it by a generic order until we get to the rulemaking stage? Do we want to wait for the normal, informal process that goes to a formal process that takes months? I think there ought to be a way to make some generic board orders that can clarify that, solve these problems as they come up. So there's a double component here. Any board members, everybody understanding what I'm trying to, I know what I mean to you.
Well, to address Mr. Moon's question, the frequency of this is just going to increase. Each year we've seen more horizontal drilling than the previous year. So I think that it's wise to take a look at it now. I mean, horizontal drilling isn't necessarily in its infancy in the state, but it's on the increase and it's here to stay. So I think looking at these things now and creating the language that Mr. Gill has recommended, I think is wise and we probably should address it sooner rather than later.
So just thinking about footage there. So that yellow box is about 10 acres, right? The blue is about 20 acres.
Correct.
So how many feet back from the section line is ideal? 500-600 feet. Correct? 500-800 feet.
To make a turn?
Yeah.
Yeah,
That's probably
And a
accurate.
40 is 1,300 feet. Or no, a 10-acre piece. So most drilling locations are about 5, 6, 7 acres. So I was just thinking footage-wise, you would have it quite common where there is another surface owner between the location, the surface location, and the section line, the drilling unit.
Right.
So it would be quite common.
And I guess the point is, we don't really know, as Mr. McDonald pointed out, we don't do title searches, so we don't really know who the surface owners are. So all we know is if it's off location, it may or may not have a different
Yeah.
surface
I mean, a lot
owner.
of
We really
40s.
don't know.
Yeah.
Okay. All right, I think the board members, do you understand the issue a little better? Division, do you feel like we understand what you wanted to teach us?
Yes, and I think we'll be addressing this most carefully in the coming weeks.
So it's not only the language that we're looking for, but it is then how to implement that language in the past and present and future scenarios.
Correct. I'd say from a permit manager standpoint, I'm not looking to overly complicate the process.
No, we
That's
think,
the-
I mean,
that's the furthest
I
from-
joked about it, but we need to give you some certainty, and we want to make sure that the companies also have a pretty good idea what the rules of the game are before they play. And so we're asking private counsel and the division and the Attorney General's office to step up and see if there's a way to just get as close to a safe haven where we've done enough that we can make it efficient and work for this. Okay, last thoughts, anybody? Seeing none, then we appreciate it. Ms. Chicken, will you get your clients ready to go?
That's what I'm going to go do. Thank you.
Thank you. Okay, the second is other.
We need to take a short break just for a few minutes to switch over to a different YouTube channel for the hearing.
Okay. But we'll just finish the briefing session. Any other items, Mr.?
I know your time is short.
No, it isn't.
I
Keep
won't
going.
belabor this. We did have in last week our Carbon Emery Collaborative meeting, which is more focused on coal mining and water issues than our Uinta Basin meeting, which is mostly oil and gas. But we aren't even having that meeting in Carbon Emery as regularly as we have Uinta Basin meeting. But we had that meeting last week on Thursday. Board Member Hanson was there, and we appreciate your attendance and participation. I'm not sure how soon we'll be doing the next one, at least within the next 6 months, and that one will probably occur in Emery County. The last one was in Price. We'll probably move back to Emery County for the next meeting. And then in July, we have our, July 12th, we have our Uinta Basin Oil and Gas Collaborative meeting in Duchesne again. And Mr. Rogers has developed an agenda that includes discussion of, some DEQ issues that we can address at this time. So if you're there and willing to attend, we welcome you to that.
Those are excellent meetings. If you have a chance to come to while we're on that subject, the DEQ has, or DAQ has a rule on methane releases that appears, or at least I've heard about it, to be in excess of federal requirements. And we'd like to get an update on what that is, just if it is an email to the board. We don't need to take a lot of time, but just what is that rule, and to what extent are people claiming that it's in excess of federal requirements and things like that?
Very well, we'll do that.
Okay.
Then lastly, I would just say that the next board field trip, the hearing will be in Salt Lake, but the field trip will be to view Rio Tinto's ongoing operations. And of course, the board gave Rio Tinto an Environmental Excellence Award this year. And so this will be a chance to look at those features on the ground that they've been doing in terms of reclamation work.
Good.
In the area.
I think that would be outstanding. Thank you.
Okay, and then I just want to thank Delta City for the accommodations today. And with that, Mr. Chairman, I will turn the time back over to you.
Thank you very much. This is the portion of our briefing session where the public is invited to talk to us about any issues that happen to be within our jurisdiction. If you'd like to come forward and address the board, seeing none, then we will take a short break. And as soon as we get a thumbs up from our court reporter, staff, and electronics folks, we will go back into the briefing session, even if it might be just a little bit early. We're not going to wait till, we're going to wait till we're ready to go, and then we'll, so as soon as you're ready to go, would you please let us know? Okay. So we're going to take a break now, and we'll come back. And thank you for that briefing. It was very helpful. We're going to try and